Our esteemed speakers, ladies and gentlemen, welcome to this critical dialogue on competition policy's role in national economic development, co-hosted by the Asian Impact Webinars and Competition Policy Dialogues. We begin with welcome remarks from Dean Tetsushi Sonobe, drawing insights from the landmark publication, Designing Competition Policy for Economic Development in Asia and the Pacific. Our distinguished panel, featuring Secretary Arsenio Balisacan, Commissioner Lolibeth Ramit-Medrano, Chief Economist Albert Park, and Professor Yasuyuki Sawada, will explore how competition policy can drive economic transformation across Asia and the Pacific. Together, we will explore a fundamental question: how can competition law and policy become more strategic tools for developing economies seeking to increase productivity and catalyze structural economic change? Starting with our speaker, Professor Tetsushi Sonobe. He is the Dean and CEO of the ADB Institute, the Tokyo-based think tank of the ADB. Previously, he was Vice President and Professor at the National Graduate Institute for Policy Studies in Japan. His research is concerned with industrial clusters, entrepreneurship, and rural sustainable development in developing countries. He's the president of the Japanese Association for Development Economics. Dean Sonobe, the floor is yours.
Okay, thank you, Yesim. Ladies and gentlemen, and valued members of the Competition Policy Network, good morning. It is a pleasure to welcome you all to this webinar titled Designing Competition Policy for Economic Development. This is a unique opportunity to engage in a discussion building on the findings of a new book published jointly by ADB and ADBI that combines legal and economic analysis for helping identify optimal competition policies in Asia and the Pacific, which is the first of the kind attempt to my knowledge. The book is a significant contribution to our understanding of how competition policy can be strategically aligned with economic development goals in the context of a rapidly changing global dynamics. As we gather here today, it is important to recognize that the landscape of competition policy in many emerging economies is undergoing a profound transformation. In developing Asia, we are witnessing a critical juncture where competition laws must be meticulously crafted to support overarching priorities such as poverty alleviation, sustainable economic growth, enhanced consumer welfare, and climate change resilience. This task requires a nuanced understanding of diverse socioeconomic realities in local context. The considerable change in the landscape of competition policy is driven by the rapid evolution of technology and its far-reaching impact on market structures. The rise of e-commerce, for instance, has fundamentally altered consumer behaviors and business models. Similarly, advanced technologies, including deep learning models, are reshaping platform-based industries and influencing labor dynamics, specialization, economies of scale, and overall market dynamics. These developments present new regulatory challenges. So this webinar, we would like to know whether or how policymakers, researchers, and development practitioners update and upgrade our competition laws and policies, keeping pace with the technological innovation and the market disruption. What competition policy frameworks can effectively drive efficiency and productivity gains? How can existing tools be revised to evaluate competition issues arising from the digital transformation of our economies? how can we enhance institutional capacities to enforce and implement competition policies and laws effectively? And importantly, how can competition policy, industrial policy, and trade policy be integrated more to achieve national development goals? This webinar aims to delve into these critical themes. It also aims to promote dialogue among various stakeholders, such as policymakers, industry representatives, researchers, civil society organizations, and so on, to better understand the implications of our policies. I would like to encourage your active participation in our discussions, both today and those that are going to be held next year under the same series, Competition Policy Dialogues. Your insights and experiences are invaluable. We hope that both the book I just mentioned and the insights that will be shared during this webinar will serve as valuable resources for all the stakeholders. Together, we can contribute to sustainable growth in our region and beyond, ensuring that our economies thrive in an era marked by rapid technological advancement and globalization. Thank you for your participation today. I wish you all a productive and enlightening webinar. Thank you very much.
Thank you very much, Dean Sonobe, for those very insightful remarks that help frame the discussion to come, raising for attention the importance of institutional and policy readiness, but also coherence going forward for successful design and implementation. On that note, allow me to briefly introduce our panelists in the order that they will be joining the discussion today. Honorable Arsenio Balisacan is a cabinet member of the Philippine government and secretary of the National Economic and Development Authority, a position he also occupied from 2012 to 2016. He has also served as the founding chairman of the Philippine Competition Commission, as professor and dean of the School of Economics at the University of the Philippines, Diliman, and as director chief executive of the Southeast Asian Regional Center for Graduate Study and Research in Agriculture. He is a well-recognized expert in Asia on economic development, antitrust, competition policy at large, and policy reforms. Commissioner Attorney Lolibeth Ramit-Medrano brings 27 years of distinguished public service to the Philippine Competition Commission. With expertise in intellectual property, public policy, and international trade, she has held critical leadership roles, including the Undersecretary of the Office of the President and Director of the Bureau of Patents at Intellectual Property Office in the Philippines. Recipient of the 2020 Presidential Gawad Career Executive Service Award, she also teaches intellectual property and competition law at leading Philippine universities. ADB Chief Economist Albert Park is the chief spokesperson for ADB on economic issues. A renowned expert on China's economy and development issues, he has held distinguished academic positions at Oxford, Michigan, and was the founding director of HKUSD's Institute for Emerging Market Studies. He has also held editorial positions at a number of leading economic journals, with extensive research on poverty, labor markets, and foreign investment, among others. Dr. Park is a leading voice in understanding Asia's economic dynamics. Professor Yasuyuki Sawada is a professor at the University of Tokyo's Faculty of Economics and serves as the director of its Center for Research and Education in Program Evaluation. He's a council member of the Science Council of Japan and served as the chief economist of the Asian Development Bank from 2017 to 2021. His research interests include development economics, economics of disaster, and field surveys and experiments. Allow me to come to you first, Secretary Balisacan. One of the key messages of the book is context matters. Could you share your insights on how development planning authorities navigate the inherent tensions between promoting domestic market competition and advancing strategic industrial priorities? For instance, in cases where industry consolidation might in fact enhance international competitiveness. Over to you.
Thank you, Yesim. Good morning, everyone. Well, in the Philippines, we place importance in mainstreaming competition policy into the government's policy architecture. This ensures that competition policy becomes part and parcel of the government's development strategy and does not exist in silo. That is divorced from other public policies. So competition authorities, especially those that have yet established a strong track record in enforcement, must humbly acknowledge that they may be considered outsiders in the policy arena, and they must be ready to navigate long-standing networks, especially among regulators and government agencies, and also establish their credibility in dealing with conglomerates to reduce pushback in their efforts to enforce competition policy. I note that for every policy objective, it is prudent to have the appropriate policy instrument. Thus, competition policy might have to be coordinated with industrial policy to ensure maximum effectiveness. Industrial policies may be used to address market failures and promote positive externalities, while competition policy must be used to discipline market outcomes or the market incumbents. Recent historical experience suggests to us that in states with weak or captured institutions, picking winners is a dangerous game and has only led to significant waste in the allocation of scarce public resources and the worsening of inequality, corruption, and the erosion of institutions that ensure economic governance, sound economic governance. Just to be sure, nothing is inherently wrong with bigness or dominance. But it must not be abused or used to foreclose competitors in both input and output markets. Industrial policy can be harnessed to promote scale without favoring any one particular group or business. For example, infrastructure development, export marketing support, enhancing innovation in ecosystem, and strengthening government academe industry linkages, as well as provision of tax incentives using well-established criteria. On the other hand, competition policy can be used to improve how markets work, even as businesses scale up their operations and become internationally competitive. For example, promoting ease of doing business and removing barriers to entry and exit, punishing cartels and abuses of dominance, as well as preventing uncompetitive mergers and acquisitions. I think I can stop there and come back to elaborate on this the next round. Thank you.
Thank you very much, Secretary Balisacan, for walking us very methodically through the importance of coherence between the two strategies and how one can actually follow the other in a sequential manner, as well as supporting each other during implementation to not only harness scale and innovation and to encourage them in the market, but to also stop short of dominance turning into abuse in certain cases in the marketplace. Allow me to come to you next, Commissioner Medrano. Staying on the same topic of coordination across different segments of an economy, rather than policy, let's come to sectors, if we may. Across different segments of the economy, in light of evolving market complexities particularly, how do competition commissions navigate jurisdictional boundaries and potential policy conflicts with sectoral regulators? Could you share your perspective on institutional mechanisms that can be effective in harmonizing the competition enforcement with the sector-specific regulation while minimizing the regulatory overlap, perhaps, and the uncertainty for businesses inevitably that may happen?
Thank you, Yesim. Good morning. Thank you for inviting the Philippine Competition Commission to this relevant discussion. For the Philippines, while regulatory agencies are given their respective mandates under different laws and statutes, there is an overarching framework provided the Philippine Development Plan 2023 to 2028, which is the National Blueprint for Economic and Social Development, of course, formulated by the NEDA, headed by Secretary Arsenio Balisacan. Chapter 10 of the PDP is devoted to the promotion of competition and improvement of regulatory efficiency. The title accurately reflects the government's recognition of the complementary and mutually reinforcing relationship that exists between competition and regulatory efficiency to enhance consumer welfare and market efficiency. One of the strategies identified in the chapter is the adoption of what we call the whole of government approach to strengthen competition, which entails sectoral regulators, the Philippine Competition Commission, LGUs, government-owned and controlled corporations, and other national agencies working together to implement the Philippine Competition Act. And to complement the PDP, the National Competition Policy was adopted through the joint memorandum circular of NEDA and PCC, headed by then Secretary Balisacan. The PCA, the PDP, and the National Competition Policy form a holistic and integrated whole of government approach on competition. This is at the macro level. At the granular level, the PCC fully recognizes the jurisdiction of sectoral regulators and vice versa. For us to do our job effectively, whether in reviewing mergers and enforcing PCA provisions, we need to work with the regulators. On this matter, we have been successful in engaging our partners in the sectoral regulation sphere. In fact, we have entered into memorandum of agreements on capacity building and data information sharing with 27 government agencies and government corporations. 11 of them are actually regulators. Specifically for mergers and acquisitions, we have a MOA with 3 sectoral regulators, and we are currently reviewing some of these MOA to be more strategic and be more responsive, learning from our experiences in the past years. We have constructive engagement and productive working relationship with a lot of these regulators. And perhaps just to cite a few examples, in a merger, in an M&A transaction involving a domestic electronic payment network, we were able to work with the Bangko Sentral ng Pilipinas. And for M&As in the energy sector, we are working with the Department of Energy and, of course, the Energy Regulatory Commission. And we engage them not only in validating data and information submitted by transacting parties or the public, but more importantly for us to understand the operations of the parties, how the market what the market conditions are, and this is part of understanding the context as earlier explained by Secretary Balisacan. So for these transactions, the quality of the assessment, the market assessment, is a function of the completeness and the quality of data that we gather, and also the relationship that we build with the other sectoral regulators. So that's it for us. Thank you, Yesim, for that question.
Thank you very much, Commissioner. So the importance of timely data, information sharing, and of course, coordination and the institutional framework that allows for that coordination to move forward. We look forward to hearing more from you on the implementation of some of these MOAs as the webinar moves forward. As we all know, there may be some challenges during implementation with a lot of goodwill and some of the institutional arrangements already in place as well. On that note, we've talked about the policy, we've talked about the intersectoral coordination, interagency coordination. What about learning from each other? Chief Economist Park, as a well-known expert on Asian economies, China in particular, how do you assess the relationship between market competition and productivity growth in the region? And what lessons can other developing economies drive from the experiences of China for designing competition policies that not only enhance market efficiency, but also industrial upgrading capabilities?
Right. I think from a development perspective, I really want to emphasize the connection between competition and growth and innovation, which is a point made by Philip Aghion and co-authors in some very influential research. And if you look at China's experience, China, of course, we know grew at double-digit rates for several decades of reform, and total factor productivity growth was a big part of that. TFP growth was 3% per year over this period, which is, historically high. And a lot of that was because the market was very open, and there was a lot of free entry, and very detailed firm level analysis shows that it was the new entrants who were very productive that really helped drive increased productivity at sector level and overall. And it was also the non-state sector. It was the private firms or collective firms that were the drivers of growth and productivity growth. So interestingly, today we hear a lot about China's industrial policies and how competitive they are in certain sectors and concerns about overcapacity. And we also see evidence that total factor productivity has really slowed quite dramatically. Now it's close to 1%, which is still better than some countries in the world, but much slower than the past when there was more competition. And I think you could argue that and actually, some of the firm data shows that this benefit to growth from new firms entering, new productive firms entering, has kind of dissipated substantially. And the other kind of odd patterns of firm level dynamics in China is that we don't really see the least productive firms exiting, which would, of course, also promote overall efficiency and growth. And we also don't really see resources being reallocated from less efficient firms to more efficient firms. Like in a place like the US, you have a pattern where firms enter, and then if they're not successful and they don't grow, they leave. But those successful ones really grow quite rapidly, and you see the biggest channel is this transfer of resources from less productive firms to more productive firms. So industrial policy in China, because it's been so state-led, it's favored incumbents. I think it's been inhibiting competition in this most recent period. And there's been good research which suggests that there's a lot of misallocation still occurring in the Chinese economy, with too many resources being allocated to state-owned enterprises, with even allocation of targeted subsidies for specific sectors not going to the most productive firms. So I think China really could take a lesson, and other countries could take a lesson from China's past when they really saw the benefits of competition. Now, what does that mean for policy? The most recent World Bank Development Report on the middle income trap also does a very nice job highlighting the importance of not protecting incumbents, not allowing the economy to have a presentation kind of mentality or institutional structure, but really focus on creation and destruction to promote greater innovation. So India also is another country where we see total factor productivity. We see firms basically not growing. They enter, they don't grow even after many years, and they also don't leave. So it doesn't seem like there's a dynamic entry and exit. And so obviously, to promote free entry, competition policy is important, but a lot of economic policies and regulations are important because we know, for instance, that oftentimes financial systems especially immature financial systems, discriminate heavily against small firms because they don't have the information or knowledge about which small firms are innovative. They tend to feel lending to larger firms is more safe, especially when the banks are state-owned banks, and they also care about preserving employment in the economy, which is kind of a government objective. And this can actually become very anti-competitive. And then, as RC pointed out, a lot of industrial policy can be anti-competitive if it is not made available broadly to all of the firms in a sector. So R&D subsidies have been found to be pretty good if they're not discriminating and widely accessible. And so that's a challenge. The tax systems and other regulatory enforcement actually can also be very unequal across firms. And sometimes it actually hurts incumbents because incumbents pay higher taxes than small firms because it's easier to enforce. And that's also not good if it inhibits the growth of incumbents and their ability. Both incumbents and entrants both have a role to play to contributing to innovation and growth. So maybe I'll stop there. Thanks.
Thank you very much, CE Park, for those very insightful comments that walked us through not only different geographies, but also different policies that have an impact and should be taken as a group in terms of their impact on the economy. And of course, competition policy is one of them. Allow me to reiterate the points that you've shared with us about the importance of, yes, there's a room for competition policy and state-led policies, perhaps, to ensure protection of both businesses and consumers, but at the same time, state-led development perhaps may not necessarily deliver the best results in the long term. And we have to be mindful of the financial systems, tax mechanisms, and of course the natural creation and destruction of new businesses or incumbent businesses based on their effectiveness should be given the space to function as well. Thank you very much for those comments. Professor Sawada, CE Park has walked us through quite a few of the developments in the economic space and how important it was, particularly in the past, for the new businesses to come in and how they drove total factor productivity and overall growth impact through innovative practices as well going forward. Now, one of the important spaces where we talk a lot about innovation and job banks, even, especially during the pandemic, is online markets and digital marketplaces. Based on your research on e-commerce and digital marketplaces, how should competition authorities approach the unique challenges posed by e-commerce platforms that simultaneously act as both marketplace operators and competitors to third-party sellers? What analytical frameworks would you recommend, for instance, for evaluating the potential conflicts of interest and their impact on market competition, particularly with the rapidly evolving digital economies where traditional market definition tools may no longer apply or prove insufficient? Over to you.
Yeah, thank you, Yesim. Good morning, everyone. Thanks for having me for this very important policy dialogue. Actually, this is a very important question, Yesim. Digital marketplaces are type of a digital platform, but characterized by a profit orientation and basically internet-based, two-sided or multi-sided markets connecting a different set of user groups. And because of this nature of digital markets, this type of markets create direct and indirect network effects. In conventional one-sided market of imperfect competition, price, how to consider theoretical price, that's a rather simple. Demand characteristics and marginal cost and market power that pin down equilibrium prices. And this can be tackled by a rather simple extension of micro economics 101, a demand and supply type of analysis. But in contrast with the existence of network externality in multi-sided or two-sided markets, digital marketplaces, a price of the one side can be zero or even negative. And this is because platformers do not only consider direct effect on one market, market A, but also the other consequences in participating in market B. For competition authorities, this would be a big challenge. I think it's quite essential to renew the theoretical antitrust type of analysis for two-sided markets or multi-sided markets in defining markets as well as evaluation of market power, assessing predatory pricing, mergers, and tying. And as Secretary Balisacan and Commissioner Ramit-Medrano said, in this type of kind of abstract statement, I think each specific industry and each sector and market context should be really carefully incorporated. For example, high markup price cost margin on one side does not necessarily indicate market power. And similarly, pricing below cost on one side does not automatically suggest predatory behavior. Mergers on one side can enhance competition on other side. So as Chief Economist Albert Park emphasized, correcting a market failure is a really foundation to achieve a better productivity and improving overall efficiency. But in this two-sided markets, I think more nuanced, a more careful extension of microeconomics is necessary. And indeed, a new theory for this type of competition and antitrust analysis became available over the last 2 decades following the contribution by Professors Jean-Charles Rochester and Jean Tirole. So I think this type of theoretical analysis, considering again a specific market context, a specific industry context, and sector characteristics, and also on top of this, as Commissioner and the Secretary emphasize, across the board, coordination, collaborations are necessary. And also not to mention, on top of this theoretical consideration, very careful empirical analysis and empirical assessments using granular data. These are also another indispensable component. And I think this is a big challenge, but not impossible mission. So I stop here. Thank you.
Thank you very much, Professor Sawada. Context matters, as we heard earlier in the session, but also we need all hands on deck. We need a deeper understanding, as you've rightly pointed out, through further analysis, and be mindful that the multi-sided nature of the online markets differ quite a bit and may be germane to different types of market failure than we see in the brick and mortar markets, and be prepared to address them through coordination among institutions, but also regulation that actually looks at it in a multifaceted way and addresses it in a multifaceted way as well. Thank you very much. Secretary Balisacan, if I may come back to you on that note of context matters and coordination. In your experience in implementing competition policy and as a cabinet member that oversees the economic development and the trajectory of the economy, which key government agencies, in your experience, have proven or can prove to be most crucial as partners in effective enforcement of the intended policy results?
Thank you, Yesim. Now, as I mentioned earlier, the mainstreaming competition policy is into the government's overall development roadmap. In the Philippines case, that roadmap is our medium-term Philippine Development Plan, or PDP, is very critical. This provides the impetus for the competition authority to exercise its mandate. For instance, as noted by Lolibeth earlier, Commissioner Lolibeth, a chapter on promoting market competition was included as priorities in the last 2 Philippine development plans. From here, it cascades into other modes and methods of implementation. For instance, in 2020, the NEDA, which is the country's national premier planning agency, and the PCC issued a joint memorandum circular implementing the national competition policy of the Philippines. This required a competition impact assessment to be undertaken by national government agencies and government-owned or controlled corporations. This eventually resulted in the issuance of a directive where the performance-based bonus, which is a monetary incentive granted to employees of the public sector, would only be granted if the agency or an agency undertakes a competition impact assessment of its policies, issuances, rules, and regulations. This project has spurred agencies to integrate a competition lens in their policies. We note, however, that this performance incentive scheme for government is currently undergoing review, and the performance-based bonus is suspended in light of the COVID-19 pandemic. As such, the CIA, the Competition Impact Assessment requirement for performance-based bonus, has also been suspended. Of course, the reality is far trickier to navigate. More often than not, policy decisions and resolutions and implementation are made by officials that champion their respective agencies' mandates in high-level interagency meetings with decision makers and legislators. Hence, as I mentioned, establishing and having a good working relationships between members of the economic team, for example, are critical. In the Philippines, we are able to advocate for pro-competitive policy decisions. However, the challenge lies in creating governance mechanisms that institutionalize this practice so that we do not have to rely solely on individuals. This can be through the passage of pro-competitive legislation. For example, in the Philippine case, the amendments to the Public Service Act, the Retail Trade Liberalization Act, Foreign Investment Act, and even our Renewable Energy Act, as well as the Public-Private Partnership Code. And the adoption of pro-competitive frameworks and policies. For example, our accession to the Regional Comprehensive Economic Partnership, as well as various issuances of government that streamline the processes and reduce the cost of doing business. The key there is to build on the reform momentum and strategically capitalize when opportunities arise to introduce pro-competitive reforms. And this is where my final note, credibility comes in. In consideration of the political economy dimensions of policymaking, credibility through the use of data and evidence is of paramount importance. This is why, to me, capacity building is important, so that you have a steady pipeline and a deep bench of experts and advocates who can proactively and strategically champion transformative and game-changing pro-competitive policies when that opportunity strikes. One legislation, for example, we are working closely with our Congress now is the Open Access and Data Protection Bill, or what we call Konektadong Pinoy Bill. With this bill, we are encouraging market contestability by removing regulatory barriers to entry in all segments of the data transmission industry, making more efficient use of scarce radio spectrum resources, improving access to telecom facilities, and strengthening enforcement and monitoring mechanisms. I can stop there and come back if we have more time.
Thank you
Yesim.
very much, Secretary Balisacan, for that very insightful look at not only be ready with legislation and regulation and interdepartmental memorandums of agreements and understandings, as Commissioner Lolibeth also mentioned earlier, but to be also opportunistic, to integrate competition lens into the policies and to the experiences, practices of relevant agencies across the government machinery, and also perhaps make advocacy the job of everyone, advocating for competition policy across the board, and opportunistically making sure that we can move the agenda forward as well from different perspectives and different sectoral interventions. Thank you. Commissioner Ramit-Medrano, you have spent incredible part of your career on intellectual property rights. You're one of our renowned experts on intellectual property rights, in fact. Now, we've been talking about means of opening up data, importance of evidence-based policy dialogue for greater credibility and also for deeper understanding, as Professor Sawada and Secretary Balisacan mentioned earlier. And in some perhaps superficial readings of IP law and competition law, it's argued that there might be some inherent tensions between the two, that the IP law, while it fosters innovation and new initiatives to come in, through the protection of the first movers, perhaps may create dominance, and that dominance may be abused in the market, which of course then competition policy has a question to ask on that one. Now, considering the increasing innovation-driven market power, how should competition authorities balance intellectual property rights protection with competition enforcement, particularly in sectors where standard essential patents or data-driven networks affect and they affect the network effects, create significant entry barriers?
Thank you for that question, Yesim. The conflict between competition and intellectual property is actually more apparent than real, as you have earlier discussed and pointed out. At first blush, IP laws, in fact, may seem to be diametrically opposed with competition or antitrust, because IP grants temporary monopolies, while antitrust or competition seeks to protect the market from monopolistic behavior. However, a closer look would in fact reveal that these two share common objectives of promoting innovation and increasing efficiency, which make them complementary rather than conflicting. In the absence of an international norm setting making or defining competition regimes or prescribing antitrust regimes, it is indeed very challenging for competition authorities all over the world to navigate this area. However, competition authorities can work with IP offices, I think, in several dimensions. One would be capacity building, as earlier explained by Secretary Balisacan. The second is in terms of data sharing or information sharing, and in a more substantive level, harmonizing policies, specifically on areas of convergence or overlap, such as technology transfer agreements or licensing involving intellectual property rights, exercise of IP right holders in the context of abuse of dominance, and enforcement of IP rights, and also the conduct of joint studies. So for the PCC, we are trying to institutionalize a mechanism between our agency and the Intellectual Property Office. We are in fact discussing a memorandum of agreement that will cover capacity building, data and information sharing, review of technology transfer arrangements, joint studies, among others. And just to mention, a few years back, the PCC conducted a study on the impact of the Cheaper Medicines Act, which amended certain provisions on patent of the Intellectual Property Code, and the Economics Office of the PCC reached out and coordinated with the Intellectual Property Office to get the relevant data and information. So we are now exploring other possibilities such as the institutionalization or the promulgation of guidelines on the licensing of IPRs that will harmonize the provisions of the Intellectual Property Code, particularly Section 87 or the prohibited clauses in TTAs, alongside alongside Section 14 on anti-competitive agreements and Section 15 on abuse of dominance of the PCA. So these are the things that we can do working together with PCC and Intellectual Property Office of the Philippines.
Thank you very much, Commissioner, for again reiterating the importance of coordination and intentional policymaking in order to address some of these potential frictions. Now, speaking of intellectual property rights and especially the importance of data and the growing importance of data-driven businesses and, of course, the online traded or the digitally traded services, for instance. Professor Park, what happens when the competition commissions cannot see under the hood? The regulatory framework development is often outpaced by the developments in technology, and especially recently, one of our greatest disruptors is artificial intelligence, an area which you have been leading research on as well. Given the rapid deployment of artificial intelligence across markets, how should competition authorities adapt their analytical frameworks and enforcement capabilities to address emerging concerns like algorithmic collusion, for instance, which is very hard to track, or AI-driven market concentration and data-based entry barriers?
Yeah, it's a very challenging issue. We know that investment in AI in the corporate sector, especially in the financial sector, has been really significant in the last couple of years. And so this issue of how AI then gets deployed and what it means for competition, I think is going to be a really important challenge because it's going to be definitely affecting business practice. If you think about how AI affects competition, it actually can go kind of both ways. In the financial sector, we have actually seen some evidence that AI has allowed smaller firms to really specialize in parts of the business process that's involved in financial services. So whereas before we had big banks that did many things for customers and both on the demand side and in terms of depositors, but also on the credit side, they could kind of cross-subsidize and be very competitive. But now you see a kind of a deep bundling of services where smaller companies can really be efficient at things like risk and credit scoring or process customization in terms of consumer support or verification of different types of compliance regulations. And of course, algorithmic trading for investment has been around for a while, actually, on Wall Street and in financial centers. But now we also have the possibility of robo-advisors replacing actual financial advisors. And so I think you could think that AI, because it overcomes lots of economies of scale, could be pro-competitive. On the other hand, we also know that to really develop a sophisticated AI capability can actually be quite expensive. So you could say large firms actually have an advantage in the investment side. And the other thing that you pointed to in terms of the negative effects on competition are, one, there could be very strong economies of scale related to data access. So if you have more data, your AI algorithms are going to be more accurate and you're going to have a competitive advantage. And the other thing is that in an AI world and a digital world, opportunities for collusion are going to be greater. And it doesn't even have to be direct collusion, but it could be tacit collusion because the key players could be designing their algorithms in a way which try to monitor what other companies are doing and tacitly collude. And it's hard to track that electronically or if it's done in a sophisticated way. And a third area where there could be reduced competition with AI is that AI can facilitate personalized pricing of services. So price discrimination, which in itself is not necessarily bad. It can, it's common practice when suppliers are able to do it. But if you use personalized pricing to like lure customers away from your competitor or do other things that are anti-competitive, that's also not easy to track. Now, at the same time, we have to keep in mind that sometimes if there are natural economies of scale, that can actually benefit consumers. Consumers want to be on a platform where there's a lot of information and where the algorithms are very accurate and they benefit from that. So that also has to be balanced. But in the case where you do have these kind of natural monopolies from data economies of scale, I think it's important still to regulate anti-competitive behavior, because these platforms could just do things which are just directly hurting potential new entrants. And it's also important to keep monitoring how they're pricing things, because they will have an incentive to overprice, right? So that needs to be regulated. Now, how do competition authorities deal with all of this complexity? I mean, of course, competition authorities also can use AI to help monitor what firms are doing if they can track behavior to key types of behavioral principles or evidence. It has to be evidence-based, of course. And the other thing that Commissioner Ramit-Medrano had pointed out was, we need to do market studies. So if there's a sector that we think is complicated or we think there's a potential, I think it can be very helpful to think about, okay, what data do we need? Let's get a consultant or one of our own staff to really do a deep dive into the sector and think about the market structure, think about the types of behavior, and really get into it to see if there's a problem. Let me stop there.
Thank you very much. Thank you very much, Chief Economist Park. And perhaps this might be a good opportunity to also share that ADB has renewed its commitment to supporting a deeper understanding of competition policy and how we may be able to address some of the challenges that are coming up in light of the market disruptors with new efforts and technical assistances that are coming up in this area. Professor Sawada, in the interest of time, if I may come to you very briefly, we've heard comprehensively from Chief Economist Park that there are market transformations happening with the artificial intelligence and machine learning on top of it as well. How should competition policy frameworks evolve to address data-driven market power and the novel barriers to entry? About 2 minutes, please, if I may.
Yes, data-driven market power and potential big barrier to the entry on a platform, for example, micro enterprises and micro merchant in the context of e-commerce. That's a potential big concern. However, as we described in chapter 12 and 13 of this book, actually we observed rather excess entries during the COVID-19 pandemic by analyzing innovative large-scale admin data from platform companies. Chapter 12, we use Alma, Alibaba's food Alma admin data, huge data covering before 1 year and after 1 year of the outbreak of COVID-19. And then we observe a positive cross-site network effect. So I think, multi-sided market positive externality we observe from the data and the substantial benefits of digitalization. However, at the same time, we found quite intense competition emerged among the merchant within the same group, and negative kind of a market stealing effect or cannibalization effect. So I think, and also Alma data tells us that these trends are particularly pronounced among the merchant on a multi-app store environment where AI and machine learning on the platforms are widely utilized. And chapter 13, using Gojek data, Indonesian data, food delivery admin data, we found a similar business cannibalization effect during the COVID-19 pandemic in Indonesia. So I believe a granular admin data is very helpful identifying a potential entry barrier or excess entry and quite complex interplay of digital adaptation, commission, and network effects. And on e-commerce digital marketplaces characterized by AI and machine learning. I think a theoretical front, I think the celebrated Monkey Winston and Suzumura Kiyono excess entry theorem needs to renewed attention. Theorem casts a doubt about the simple validity of traditional belief. Relative efficiency of resource allocation increases monotonically as number of firms expands, a number of entrants expands. This is exactly what we found in a platform in China and Indonesian platform. So in the future, I think it would be very important from the theoretical front, examine in context of multi-sided market, whether this excess entry theorem falls short of justifying a competition and industrial policy that regulate the competition for the sake of keeping excess competition under control. So I think theoretical front we can dig deeper along the side of Monkey Winston Suzumura Kiyono excess entry theorem. Alongside, we can proactively utilize large-scale admin data from e-commerce platforms to really identify what's the market situation in a specific sector and specific market context. And then by doing so, I think we can come up with a better understanding of the way forward to coordinate across the different policies. So.
Thank you.
Thank you. Yeah.
Thank you very much, Professor Sawada. We also have some questions coming from the floor. If I may address it to Secretary Balisacan and Professor Albert Park, how are competition policies designed to protect smaller nations, which are indirectly influenced, impacted by the digital market of larger nations? Secretary Balisacan, if you'd like to start.
Very briefly. Yes, I think facing the challenges is quite, especially for young competition authorities in small countries, because as Albert mentioned, there's a high cost to developing that particular expertise particularly in the AI world. And what we have tried to do in PCC at the time when we were investigating this global merger, regional merger, was to coordinate our actions among these different competition authorities in the region, as well as work closely with other competition authorities in some regions of the world. And I think that building that sharing of expertise and information proved to be very useful in coming up with a case that supports the interests of the country. I think that's the most practical approach that we can deploy in this particular case because, as I said, this is a big brother's game.
Thank you very much. Professor Park?
Yeah, I think these cross-border digital platform issues have to be addressed collectively. And I think countries need to think about, they need to think about the interest of their own consumers and businesses if those services are beneficial and not, react just instinctively against, some foreign platform doing a lot of business in their country. But obviously there are issues about taxation, which are quite complicated, which are being addressed in international fora for digital services. And I think that's the right way to think about it, because you want the treatment to be fair and consistent. And you also don't want to disincentivize digital firms to, enter the market. Sometimes that can actually be helpful to consumers and also can lead to competition, of course, and give ideas for local entrepreneurs to also think about how to enter the digital space.
Thank you very much. If I may come to you very briefly, Commissioner Ramit-Medrano, there's a question about the stance on the right of repair in relation to intellectual property and competition. In about 1 minute, if you could share with us your thoughts.
Okay, I think that's another area where the Intellectual Property Office and the PCC could work on having this joint guideline on the right of way there. As we have seen in the experience of the US and the EU, there's really a guideline already on this matter. So that's something that the smaller jurisdictions like the Philippines could look into and learn from the experience of the US and the EU.
Thank you very much. And Professor Sawada, very briefly, there was a question about the COP and sustainability with respect to policymaking for economic development.
So actually, in the context of e-commerce, at the same time helping achieve global climate target is really critical. And e-commerce involves merchants, users, delivery riders, logistics, and financial settlements, and broader institutional infrastructure, control privacy and data security issues, and then achieving a fair competition environment. And so I think by nature of digital, I think it's also relatively easier to set some criteria and some regulatory framework to achieve a better climate goals. So I think concerning this multifaceted, multi-interdisciplinary environment, I think a competition authority can play a very, very important role to help achieve a COP targets.
Thank you. Thank you very much, Professor Sawada and all our panelists. We've come to the end of today's session, jointly hosted by the Asian Impact Webinars and Competition Policy Dialogues. I'd like to thank our audience for your active participation. We've had a lot of interesting questions. Apologies for those we have not been able to attend to given the time limitations. We look forward to your participation in future events for us to continue the conversation. Before we close today's webinar, we would also like to invite you to join our next Asian Impact webinar on the Enhancing MSME Development in Timor-Leste, to be held on 5th of December. It will be held again by Zoom, and our competition policy dialogues will continue next year as well. More information will be shared through the AIW and the CPD websites, and of course our Chief Economist's X account. Until then, please join me in extending our deep appreciation to our esteemed guests, Dean Sonobe, Honorable Arsenio Balisacan, Commissioner Lolibeth Medrano, Chief Economist Albert Park, and Professor Yasuyuki Sawada for their valuable contributions. Thank you for joining us, and I wish you all a very good morning from Manila, Philippines.